All right, this is part 3 of the recap from today's Rule 62 hearing. Just FYI, the first 2 parts have the meat and potatoes. I'm wrapping it up now, so please make sure that you're watching the first 2 parts. As always, I am a certified law nerd, bona fide non-attorney. This is not legal advice. This is my interpretation, yada, yada, yada. I'm just putting that out there. Oh, Lord. Okay, ready. So now we are on to the direct examination of Akira's mother, Attorney Sidner. She was obviously directly examined by Attorney Robin. Here she testified that Brenay's claims of supporting the children are very untrue. She stated that she knows that because she is primary financial support for Akira and her kids. She pays for things such as daycare, food, clothes, trips. Anything that is bought at Brenay's house stays at Brenay's house. She also testified that Brenay benefits financially from discussing the kids and Akira online. That was basically the gist of the direct examination. It wasn't too long, but when we got to cross-examination with Attorney Fairman, here she acknowledged, and Attorney Fairman did bring up a couple of points, and I'm very interested for you all to opine. She asked Attorney Sidner if negative statements made about Brenay, if statements made on social media about Brenay could be considered negative. And she used one example of a comment that was left on one of Ninja's live streams or videos, I don't know which, where somebody said Tim and Brenay, quote, Tim and Brenay are going to be in debt for life. She asked Attorney Sidner if that could be considered negative. Attorney Sidner said yes. There was another mention of a video that said liar, liar, fibber, fibber, and Attorney Sidner was like, I mean, that could be about anybody. That was a TikTok trend. Kind of doubled down about the statement, saying it's very clear that she's got money to spend because she does spend a lot of money on things that you shouldn't be spending money on. That's kind of the whole point and the argument of if you have a $2 million judgment against you, maybe you should be calming down. Or if you know that a lawsuit is coming against you. This did just trigger a memory. I just remembered what this was referring to. When she bought the car, sorry, I gotta circle all the way back to Brenay for a second. When she bought the car, they asked her, you don't think that that was a bad idea given the fact that you had an upcoming lawsuit? And she said, no, because I didn't think I was gonna lose the lawsuit. And then she goes, but you did lose. And she goes, yes, because of your lies. Sorry, I just wanted to throw that out there because I just got triggered on something. Okay, so then we got to a point where we were discussing the fast food so much in court that Attorney Robin was trying to show a statement. She was trying to prove that, hey, we're not saying that buying a burger at McDonald's is the problem. We're saying that almost $5,000 in fast food is a problem, right? So they have Attorney Sidner reviewing the statements. Attorney Robin joins her, and then Attorney Fairman joins her. And eventually the judge was like, okay, everybody back to their seat. I've heard enough about the food. So that's your little comic relief for a second. He was not happy. I mean, he didn't find it funny, but in my head, I'm just like, yeah, that is a lot of fast food we're talking about. And then that was kind of it. From there, the testimony died down. Closing arguments from the defense were pretty straightforward. I can actually read those to you verbatim. This case is on appeal. Rule 62 applies here. Brenay's income has gone down. She lives with someone who brings home $500 a month. That was the testimony that Tim made $500, that takes home $500 a month. That's what people with not a lot of money do, according to Attorney Fairman. People with not a lot of money eat at McDonald's and go to Walmart. And shop at Walmart. And so Brenay requested a $10,000 secured bond. We're going to get into that, I promise. Requested a $10,000 secured bond, and the defense rests. Then Attorney Robin jumps in and says, okay, this is a almost $2 million judgment. We have looked at the statements together. Her income has not changed drastically from before the trial versus after the trial. We've reviewed a year of statements. And we don't feel like this is sufficient. We are requesting a $40,000 bond. She has an able-bodied partner at home that can help her. And we just feel like that is a much more fair number than $10,000 because this is a $2 million judgment. Let me stop right here, okay? This is a big shift from what we expected to see. What we expected to see with the supersedious bond was the full amount of the judgment plus interest and costs. That's typically what a supersedeas bond looks like, especially at a federal level. However, the reason it surprised me too, it threw me for a loop, so I had to come back and read, okay? And when I go back to the statute, it mentions the supersedeas bond, but it does not mention the requirement that the supersedeas bond be at the full judgment amount. And remember, I've told you this from the beginning. When it comes to interpreting the law, you have to interpret what is written and what is not written. That is very important. In this case, because there is no requirement for how much that supersedeas bond has to be, that is discretionary, which means the judge can determine that. And the courts are typically not going to impose a appeal bond that could impede or what's the word I'm looking for? They don't want to make the appeal impossible. Does that make sense? So you don't want to impair her ability to appeal because you've made the appeal bond so high that it's impossible for her to proceed with her appeal. Because now, $2 million, that's a whole lot of money, right? So it's important to remember that. That's why these amounts were discretionary, right? First off, the court is then asking defendant and plaintiff what they are recommending to the court. And that is why we got $10,000 from Brenay, $40,000 from Akira. So, like I said, they requested $40,000. This is where judge issued a ruling from the bench. He recapped the jury verdict. He recapped the Rule 59 denial. He mentioned that the case is now on appeal. He said that Brenay's income has not meaningfully decreased. It hasn't. On paper, you can see throughout the year, before and after trial, her income didn't really decrease. He did make a notable comment. He kind of went for the attorneys a little bit and said, I'm noticing that the attorneys tend to take on the persona of their clients. Maybe we can chill on that. He didn't say it in those words, obviously, but I feel like that's what he was trying to say. But then he also made another comment, a very pointed comment, stating, there's good publicity, and that's obviously better than bad publicity, but it appears that in this case, bad publicity is better than no publicity, because that seems to keep bankrolling the social media. And he did grant Akira's request for a $40,000 secured bond. What does that mean? It means that in order for the collection to pause while Brenay's appeal is pending, she has to secure $40,000, either through a surety company or through a cash bond. That is what is being asked of her. If she cannot do that, the appeal can proceed. However, there is no pause on collection. Okay? And finds it fair given the circumstances and given the request to the court, But before adjourning, the judge basically did say this is getting out of hand, and his last words before adjourning was he looked at both sides and then directly at the defendant and said, just stop. So that's your recap. Holy moly. That took 30 minutes. So I hope, well, not 30 minutes exactly, but I hope you enjoyed that. Sorry, I know this is not my typical style, but I know you guys want the deets and you want it fast. So this is the fast version of that, okay? If you have any questions or concerns, I am happy to address them to the best of my ability. And if not, I'll catch you in the next one.